The privacy rule has a number of administrative requirements. First of all, each covered entity has to appoint a privacy official, an officer, a contact person for complaints of violations. You have Christine here as your privacy officer, right there. Sorry, let's go back. Training, mandatory. You're here, you're fulfilling that requirement, but it is required under HIPAA that all employees that have access to or contact with protected health information undergo training. So that part has been accomplished today. Every covered entity has to have safeguards in place. Nick talked about, I believe, some of the IT safeguards in place for protecting the health information. Every covered entity has to have a format for filing complaints. Yours is Christine, and we'll talk about that, how either an employee or an individual becomes aware of a violation or a breach and would want to file a complaint. Employee sanctions is another piece of the administrative requirements. Employees that are found guilty of violating HIPAA, again, it depends if it's a knowing violation or an inadvertent violation, but there are sanctions in place for employees that covered entities have to follow. Every covered entity has to mitigate any breaches. So if they become aware of a violation of HIPAA, they have to do everything in their power to minimize the damage. Intimidating or retaliatory acts. No beneficiary under a plan can be subject to a retaliatory act for filing a complaint, for making a request for further information. We'll talk about some of the individual rights that each beneficiary has, access to their PHI. They can't be discriminated against or retaliated against for exercising their rights. They can't be asked to waive their rights also. Another administrative requirement is no waiver of rights. Every covered entity has to have policies and procedures in place. Johnson & Wales does. And then finally, we'll talk about this later, every covered entity has to have documentation policies for preserving and maintaining documents, different HIPAA requests, the policies, things like that. It's 6 years is the limit, but we'll get to that. So under the HIPAA privacy policy, Christine is the privacy officer, the privacy compliance team, and if you have anything to add to this, but all the employees who perform administrative functions on behalf of the plan, apparently everyone here is a member of the privacy compliance team. So everyone has access to PHI in this room. Everyone is subject to the privacy rule under HIPAA. How do we use and disclose protected health information under HIPAA? The PHI, Christine mentioned, the enrollment forms, the beneficiary information that's come across your desk every day. There are 3 ways we can use and disclose PHI. There are permitted uses and disclosures, there's mandatory uses and disclosures, and there's authorized uses and disclosures. The permitted uses and disclosures are the 3 big ones. It's TPO is the acronym. Permitted to disclose and use PHI for the purposes of treatment is the T, for purposes of payment, and healthcare operations. Treatment is, I think, pretty self-explanatory. Providers can use for provision of care, for consultations, for referrals. Disclosures for payment purposes. This is your billing, this is filing claims, this is reimbursement, this is data processing. And then finally, healthcare operations is the administration of the plan. Your internal, if you're filing reports, if you're reviewing past performance of the plan, things like that fall into the operations bucket. If the disclosure is not recurring, if it's a sort of a one-off or unusual request, see Christine, see your privacy officer. If it's your day-to-day filing reports, submitting claims, processing enrollment, that again falls under treatment payment operations and is permitted without assigned authorization from the beneficiary. A few other permitted use and disclosures. Again, these are the uses and disclosures that do not require authorization. Any uses, any disclosures to the individual. If you're sending anyone a mailing containing their information, you don't need their approval. Incidental use and disclosure. It's kind of a funny line, and I hate that it's part of HIPAA because everyone always asks what's incidental. The example I like to give is you're faxing a report or a fax to someone that contains private information. You leave the fax on the fax machine. Your colleague walks by and picks it up and looks at it and says, "Oh, you left this on the fax." Incidental. You don't want to ask you don't want to go too far beyond that because then you start to get into a breach. But you like to say you know it when you see it. Uses and disclosures with the opportunity to agree or object. There are certain non-formal and informal uses and disclosures. Anytime then you have a prescription at the pharmacy and your husband or wife goes and picks it up, they're accessing your personal health information, but the pharmacist considers them to have authorization to pick it up. Limited data sets. The plan may use and disclose information pursuant to a limited data set, which is it's a form of data use that the plan may compile information and send it to a third-party vendor for research, for analysis. This is subject to a data use agreement between the university and whoever the vendor is, so there is some confidentiality protections in place with limited data sets. Finally, there are a whole host of examples under HIPAA for public interest and benefit activities. A few of them are, you may disclose to law enforcement officials for law enforcement purposes, pursuant to a court order or a subpoena. Sometimes you'll get a subpoena in the matter of a divorce proceeding, and they'll want to release the wife or the husband's medical records. If you're acting in accordance to a subpoena, that's permitted without authorization. And again, I can't stress it enough. If you have any questions about a request, see your privacy officer, see Christine. A few other public interest benefit activities. If there is an imminent threat of risk or bodily harm, if there's some damage that's going to come, you can alert law enforcement officials without violating HIPAA, sort of a carve out to protect that. Two types of required use. The first is if the individual specifically requests access to or an accounting of the disclosures made of their protected health information, you must disclose to them. This does not include, there's an exception for psychotherapy notes, or if the information is compiled by JW in anticipation of a legal proceeding, you don't have to share that with the individual that's making the request. The second is to Health and Human Services. If they're undergoing an investigation, then you must disclose any protected health information that they ask for, again, without authorization of the individual. Everything else is forbidden, is prevented from using and disclosing unless you have the written authorization from the individual. Aside from using it for payment, treatment, healthcare operations, some of the public policy exceptions, everything else needs a signed authorization. Contact Christine to determine whether we have one on file from the individual making the request. All use and disclosures made pursuant to an authorization. The authorization will contain the terms. They'll contain a description of what information is being disclosed. They will contain the name of the recipient, who's receiving it, who's going to be, what they're going to be using it for. It has to be a very detailed authorization. It must be dated. It can't be expired. It can't be 10 years after the individual signed the authorization. All uses and disclosures, whether they are the permitted uses and disclosures, the payment, the treatment, the operations, whether it's a required use and disclosure, whether it's an authorized use and disclosure, every use and disclosure has to be subject to the minimum necessary standard. What this is you must make reasonable efforts to minimize the amount of PHI needed to accomplish the purpose of the use or disclosure. Like to ask yourself two questions. You say first, is this disclosure necessary? Is it the minimum? An example of this would be a billing company contacts you and says, has Mrs. Smith, we're calling to confirm that Mrs. Smith had her procedure last week. What was the date of procedure? You can provide that information that is pursuant to payment or treatment. That's a permitted disclosure. What you can't do is you can't tell them the results of the treatment. You can't say that it was a negative result. You can't say any other information beyond what they were asking for. Minimum necessary. You keep the disclosures to the minimum, absolute minimum necessary to perform the task. Of course, everything has exceptions. If it's a pursuant to valid authorization, we have the authorization form on file. Then you may disclose to the extent that the authorization permits it. So you don't have to go through the sort of analysis of what's the minimum disclosure that's required here. Whatever the authorization allows you to, that's what you can disclose. Any disclosures to a provider for treatment, we want the beneficiary's doctors to have the full file, the full information, not subject to the minimum necessary standard. If it's to the individual, again, you don't have to conform to the minimum necessary standard. Disclosures to HHS for investigations, these required disclosures, not subject. If it's required by law, and then there are several other exceptions within the administrative simplifications rule, which I have yet to see come into play, but just aware that there are other exceptions for when you have to use the minimum necessary standard. Keeping good documentation is absolutely crucial. Whenever a disclosure is made, you want to document the date of disclosure, who received the PHI, the address would be great, brief description of the protected health information that was disclosed, statement of why, the purpose of the disclosure, why it was used, other things that must be documented and retained, JW's notice of privacy practices that go to all plan beneficiaries, any authorization forms that we have on file, any beneficiary requests for information, they can request to amend their PHI, they can request an accounting, any request, any communications with a plan beneficiary you want to keep on file. HIPAA requires to be on file for 6 years from the day the documents were either created or last in effect. If any policy has been modified, then 6 years from the date of modification. You will receive requests from beneficiaries' spouses and their parents and their family members and their friends. What do you do when you get a call from Mrs. Smith's husband and say, can you let me know this piece of information, or is my son enrolled in this? Generally, the individual who's the subject of the PHI must be informed. They must be given the opportunity to agree or to restrict. If it's from the parent of a minor child, I'm not sure that would come into play with the beneficiaries of the university's plan, but we'll talk about how to verify an individual's identity. An individual is permitted to restrict to whom the information is provided. They can call you up and say, I don't want you sending my information to these people. We must agree to that, and that must go on file, must be documented. But you will receive requests from someone who's not the subject of the PHI, and you have to verify their identity. This can be either a government ID, if you're over the phone, a social security number. If it's a parent of a child, you want to verify the relationship. If someone is calling on behalf of an estate or a personal representative, you would like to request a copy of their power of attorney that allows them to access a person's personal protected health information. If you're contacted by HHS, local law enforcement, request to keep a copy of the credentials. Obviously ask questions before you start sending information out. Verify everything on letterhead. Again, keep copies of everything for the 6 years requirement, but maintain good copies of all documents. And obviously, if any requests come in for subpoenas or court orders, see Christine, but I would even say see Christine for any other sort of requests out of the ordinary. Additional safeguards. You're using a disclosing PHI in accordance with the privacy rule, but you have to keep additional safeguards. Nick covered last hour a number of different IT safeguards for computers. It's really common sense things. PHI must be kept locked away. Don't keep it on your desk. It must be stored in a secure network. Johnson & Wales, all covered entities are not allowed to sell PHI for compensation, so that the bullet on no direct remuneration in exchange for PHI or marketing communications. Do you want to talk about fundraising issues briefly? It rarely comes into play. The privacy rule has requirements if you're going to use PHI for fundraising or marketing purposes, but again, it's very rarely used. A couple other safeguards, again, common sense. You're sending out faxes, keep track of the faxes, keep track of the documents. If you have shredders, use them. You don't want these documents to float around. A large number of HIPAA violations come in from lost USB drives, lost laptops, files that are left taken out of the office and lost. These are all violations, these are all breaches, they're all reported. They all have civil or criminal penalties involved, but it's simple things. It's just keeping track of the information. Leaving voicemails is another often a violation. You call up someone to respond to a request, and you say, I'm calling about this, and you say the protected information. You give a piece of information over the voicemail, you leave it on the answering machine. that's a violation. Try to keep it to, I'm calling on behalf of JW. Please call me back and leave the information out of the message. All plan beneficiaries have rights to, under the privacy rule. Sorry, they have to receive the notice of privacy practices, and when they enroll in the plan, they will receive the packet. This is one of the documents they will receive. It tells them what their rights are. It tells them what JW has to do with their information, their uses and disclosures. It informs them of their right to access their PHI at any time. They can contact your offices and get a copy of their file. They have a right to amend their PHI if they believe that what's contained in their file is incorrect or incomplete. They have a right to request an accounting. Please send me a list of everywhere you've sent my PHI. If you've sent to any third-party vendors or any outside parties, they can request a list of all disclosures of their information. They have the right to request an alternate communication means. If they don't want you sending their information or mailing to their home address, if they prefer to receive it at work, you have sort of confidential matters sometimes, and some people don't want their information being sent to their home address where any member of the family can pick up a medical record, for example. And finally, I mentioned this before, a right to restriction request if they don't want a certain member of their family or some other individual from accessing their files or requesting PHI, they can request that only they receive and only they are contacted. This comes into play. We get calls, excuse me, from clients going through custody battles or a divorce dispute where they don't want their ex-husband or ex-wife getting access to their medical files. So they can request that the covered entity restrict who has access to their files. And finally, the individuals have the right to file a complaint. If they become aware of any breach of their PHI or think that there has been a breach of their PHI, they have a right to complain either directly to HHS, which will launch an investigation, or you will get a phone call and refer it to Christine and follow through in that manner. Employee sanctions required under the privacy rule. Both the WISP and the privacy rule require that all employees comply with requirements. Sanctions will be imposed against any employee. Each covered entity has their own internal policies, but failure to comply will be subject to sanctions, including termination of employment, depending on how egregious the violation is. Again, these are mandatory and must be imposed by JWU. Covered this earlier, but Johnson Wales cannot retaliate against any individual, a member of a plan, for exercising their rights, for requesting access to their PHI, for requesting a disclosure of accounting. No employee can intimidate, threaten, coerce, discriminate against anyone for exercising their rights. For filing complaints, for contacting HHS, launching an investigation, they are protected. These are their inalienable rights. Again, covered that no individual could be required to waive any of their rights as a condition of signing up, as a condition of enrollment or eligibility in the plan. Who else is covered by the privacy rule? We have the covered entities. These are the providers, the clearinghouses, and the plan. The plan will contract with third-party vendors, your billing companies, your legal counsel, your accountants. There will be other parties where you will need to send information to them so that they can do their job. If I get a call for a legal question that requires my client to send me information about a patient, that is a disclosure of the information to me. I am a business associate, is the term used under the privacy rule, performing certain functions or activities on behalf of the covered entity. A few examples there, claims processing, the legal, accounting, consulting, things like that. The covered entity, JW, must enter into a business associate agreement with any third party to whom PHI is shared. That business associate agreement will cover the confidentiality, will cover liability. The business associate will be liable if they have a breach on their end. They have their own duties and responsibilities under HIPAA. They must notify JW. They must notify the covered entity if there is a breach on their side of things. The Affordable Care Act, Obamacare, has strengthened some of these requirements. So now the business associate and the covered entity are both on the same footing. If there's a violation on one end, the other is equally liable. Before, it was the business associates. If they had a violation, it was on the covered entity. The covered entity had to keep track of their business associates, but now the business associate is also liable. And I believe that there are business associate agreements on file. Each of the vendors you use, Shred-it, Ben Strat, Blue Cross Blue Shield, Dental, some of the vendors that you have contracts with, there is a business associate agreement on file that says we will be sharing our beneficiaries' PHI with you. You must keep it confidential, subject to the HIPAA privacy rules. Breaches are violations of the privacy rule. The formal definition under HIPAA is impermissible use or disclosure that compromises the security or privacy of the PHI, such that the use or disclosure poses a significant risk of financial, reputational, or other harm to the affected individual. There must be an element of harm. The fax copy that's picked up on the fax machine, you could argue that there's no damage to the individual because it's one of your colleagues looking at it. You don't want to go down this road. This is a violation. HIPAA requires, depending on the severity of the breach, how many beneficiaries are involved and affected. There are different levels of reporting. If it's over 500 individuals, you must notify HHS. If it's a larger breach than that, you actually have to notify the media so that they can post either a news report or a newspaper article to notify. When Blue Cross Blue Shield of Rhode Island had the incident where thousands of beneficiaries' information was sent off to a third party in a desk drawer, they had to, I believe they printed it in the newspaper, notifying if you are subject, if you've been affected by this, contact us. You have to notify the people. So different levels of breaches have different ramifications and responsibilities. What should you do if you're concerned that a breach has occurred? First, report it to your privacy officer. The ISM is
Actually,
yeah, absolutely. Come on up, please.
The methodology that we've created is to call safety and security first. Why? Because they're available 24/7, and every once in a while somebody's laptop gets stolen and safety and security actually goes and chases them down with the police, and once or twice they've managed to get the equipment back. So if it's a physical stealing, something like that, safety and security will be able to address it right away. If it's something that's electronic, what safety and security is going to do is they're going to call Nick right away or the help desk and get on that right away. With respect to possible PHI breaches, that's also going to go to Christine, so she's looking at that as well. You know, the bit about there has to be some harm, the analysis can get pretty darn complicated about whether there's been a breach or not a breach. We're going to leave that to the ISM and the privacy officer and the general counsel's office to figure that out. So as Nick said, if you even suspect or have a glimmer of an issue, it would be better to call and discuss it. And as Andy said, we also have to consider our business associates as well. So it does get quite complicated, and good communication will help, and you guys have been great so far on that.